Grazie Fabrizio. Dirò qualcosa in italiano, poi farò l'intervento in inglese. Grazie anzitutto a tutti i presenti superstiti della giornata di ieri, che è stata davvero molto, molto piena. Abbiamo avuto delle sessioni molto interessanti, anche questa stamattina sono stati ripresi e approfonditi concetti che erano stati approfonditi in relazioni presentate ieri. Il titolo che ho dato alla mia presentazione è stato volontariamente mantenuto un po' generico e fluido, in quanto durante i convegni mi piace trasformare il contenuto dell'intervento in base agli interventi precedenti, in modo tale da non ripetere quanto è stato già detto. Thank you very much, everybody, for being here today. So I'm going to give this presentation in English. The title is The International Protection of Freedom of Belief, Recent Developments. I will be focusing mainly on 3 points regarding freedom of belief, which are the education and right of minors belonging to religious minorities, the problem, the issue which has been yesterday, some of the speakers have already spoken about this, the requirement of registration and re-registration and liquidation of religious confessions in some countries belonging to the Council of Europe, and then the very important issue of the granting of the refugee status to people applying on the ground of religious persecution. As you can see in the middle of the stage, the European Federation for Freedom of Belief is making a call to the European nations to promote and implement freedom of belief, thought, conscience, and religion in the European countries. In this call, we have recalled the most important legislation on human rights concerning freedom of belief in the world, starting from the Universal Declaration on Human Rights of 1948, whose Article 18 is the most comprehensive article available at this time regarding freedom of belief for all the people. The Universal Declaration as such was not binding because it was just a declaration, it was not a convention, it was not a covenant. So it needed to be transformed into something binding. So the UN adopted the International Covenant on Civil and Political Rights in 1966. It took 18 years to adopt this covenant. Even though the Universal Declaration as such is not binding, in 1968, the UN, in the Proclamation of Tehran, said that the Universal Declaration is in fact binding. It does constitute an obligation for the states to respect the human rights of all human beings. The content of the Universal Declaration of Human Rights was transported into Europe with the European Convention on Human Rights of 1950. So just 2 years after the Universal Declaration of Human Rights, the European states, at a very important time after the war, they decided to adopt this European Convention on Human Rights. Regarding freedom of belief, thought, conscience, and religion are protected in Article 9. Article 9 of the Convention is divided into 2 different paragraphs. Paragraph 1 enlists the contents of freedom of religion, and paragraph 2 gives the elaborates around the limitations that are allowed. Going into the content of the presentation regarding education and minors, I want to recall something that happened in 2014 in Strasbourg. A report called The Protection of Minors Against the Excesses of Sects was presented by Mr. Rudi Salz, MP, and was scheduled to be voted at the Parliamentary Assembly, that eventually did not approve it. Let's have a look at some of the provisions contained in that document. Among other provisions, the Salz report was calling on member states to set up centers on sect-like religious and spiritual movements. The aims of such centers were not specified in the report, so it could have been to study about religious minorities called sects, maybe to provide information, and maybe to organize fight campaigns in a French-like style. Other point, aim was to provide judges and police officers and ombudsmen and the welfare services with information about cults and sects. And also, this is a very important point, to support, including in financial terms, the action of private bodies, which basically means to justify the state funding of anti-cultic and anti-religious organizations. Yesterday, Dr. Duval spoke about the fact that the international organization called FECRIS is being funded by the French government. If this kind of report would have been transformed into legislation, states would have been allowed to fund legally this kind of organization. And all of this would have been conflicting with the previous recommendation of the Council of Europe of 1992 and 1999, when the Council of Europe made it clear that the public authorities have to be neutral. They cannot set up any centers whose aims and activities may be conflicting with the rights of religious minorities, often referred to as sects and cults. And the Council of Europe also stated in 1992 and 1999 that the ordinary civil and criminal law do have all the instruments necessary to deal with cases originating in the religious communities, as Professor Carobene was saying just earlier. We can imagine that a legislation like the one proposed by Rudi Salz would have been affecting the lives of thousands of people living in Europe. So we can guess that behind this kind of proposal there has been a very important work being done. The explanatory memorandum to the report of Rudi Salz was giving an idea of what was the work that had been done to reach this proposal. This report was basically the result of, and I quote, one meeting the committee had in one day with one scholar, Professor von Bijsterveld from the Netherlands, one lawyer and representative of Family and Personality Protection Society, and the French politician and former president of the Miviludes, Georges Fenech. The second tool used to elaborate this proposal was a questionnaire that was sent to member states' parliamentary assembly. The third tool used to elaborate on this proposal were 2 one-day visits that Mr. Sals had with representatives of anti-cultic associations in Stockholm and in Berlin. So we can say that the work behind this report was not scientific, nor was it neutral at all, nor was it balanced, because they only heard the voice of anti-cultic and anti-religious associations. I was asked to make a comment on this proposal, and in a very provocative way I said, I would rather make a proposal on the protection of minors against the excesses of anti-religious groups. With the aim to protect minors, acknowledging and implementing their right to freedom of thought, conscience, and religion in an effective way, additionally protecting their right to education in conformity with the desires of their parents. 4 years later, in the same place in Strasbourg, the Parliamentary Assembly of the Council of Europe approved and passed Resolution 2163 of 2017 on the protection of the rights of parents and children belonging to religious minorities, with which the Parliamentary Assembly, by reaffirming the right to freedom of thought, conscience, and religion for all individuals, calls on all member states to perform effective actions to enable the free exercise of own belief in public and in private within defined limits, and to repeal any laws or rules which establish a discriminatory distinction between religious minorities and majority beliefs, and also to implement easy-to-follow procedures to obtain exemption from compulsory religious education. For instance, through providing non-confessional religious classes or providing information on a plurality of religion and ethics programs as well. All of this is perfectly in line with our aspiration and aims as the European Federation for Freedom of Belief. So we have recalled the content of this very important resolution, which is the opposite of what Mr. Sals had proposed 4 years ago in the call to the European nations. The second topic I want to cover is the requirement of registration and re-registration and liquidation of religious groups. We must say that over the last few years, particularly the last 15 years, the European Court of Human Rights has been dealing with a number of cases originating in countries that had passed legislation on the registration and re-registration of minority groups. We cannot recall all of them, but I want to recall a very important case, the case of Church of Scientology of Moscow versus Russia, where the court found a violation of the Convention, European Convention on Human Rights, as the authorities tried to justify in any possible way the refusal to grant the registration to this church because this religion was considered as a cult. A very, very recent case, it's less than 1 year ago, the European Court of Human Rights issued a judgment in the case, which is a very difficult to pronounce, name Magyaros Gári Evangeliumi Teszterokoszeg versus Hungary. This is a very interesting case because the court first dealt with this case in 2014, finding a violation of the convention. And in 2017, the European Court granted a lump sum of money to the applicant church. This church was operating lawfully on the basis of the actual legislation of the country of Hungary, the legislation on registration of religious groups. A new legislation was adopted, passed, and entered into force in 2012, and this church, like other churches, was deregistered. Such legislation was allowing public authorities discretionary powers for the re-registration of denominations in the country. The applicant church went to Strasbourg and, relying on Article 9, freedom of religion, of belief, and Article 10, freedom of association, filed a complaint. As I said, the case was charged in the merits in 2014, when the court found out that the national authorities had failed to be neutral by removing the registration status to the applicant, as in fact the authorities could have used less stringent criteria. What is very interesting is that the court unanimously decided to grant a just satisfaction in the form of pecuniary damage of 3 million euro to the applicant church. This is very interesting for the reason that the judgments of the European Court of Human Rights are binding, and states have to take any action to change the legislation that has caused the violation of the convention. Not all states, unfortunately, take this kind of action. There are states that not even follow the judgment of the European Court of Human Rights. And when this kind of denying goes on, something may happen to these states, and we will see what may happen. Apart from registration, re-registration, and deregistration, when state authorities go further, as they did with Jehovah's Witnesses in Russia, they could even liquidate the religious group. That in case of Jehovah's Witnesses were liquidated on the statement that they were, on the allegation they are an extremist group. Unfortunately, what happened to the Jehovah's Witnesses in Russia is not limited to the Jehovah's Witnesses, because what's going on in Russia, and it's been happening for a few years now, it's also involving other peaceful communities that include the Church of Scientology, Muslim communities, Christian Baptist churches, and the list is longer. So as I said, something may happen to these states belonging to the Council of Europe, not observing, not following the judgment of the European Court of Human Rights. So some of you is wondering, is anything happening from the side of Council of Europe in regards to the Russian Federation case? Well, 1 week ago, the 12th of February, the Parliamentary Assembly of the Council of Europe, in document 14467, entitled Russian Federation Ban on Jehovah's Witnesses, says, the Committee of Ministers has discussed the events relating to the liquidation of the administrative center and 395 local religious organizations of Jehovah's Witnesses following the judgment of the Supreme Court of the Russian Federation of July 2017. The Russian delegation has provided information in this respect. The committee is following these developments closely in light of the settled case law of the European Court of Human Rights under Article 9 of the Convention. Freedom of religion, including the freedom to manifest one's religion alone or in community with others, is one of the foundations of a pluralistic democratic society and one of the most vital elements that go to make up the identity of believers and their conception of life. At its human rights meeting of December 2017, the committee examined 2 cases against the Russian Federation concerning violation of the rights of Jehovah's Witnesses under Articles 9 and 11 of the Convention, namely Jehovah's Witnesses of Moscow and others, and Krupko and others. The committee decided to transfer both cases to the enhanced supervision track, and inter alia invited the authorities to provide information without prejudice to the European Court's examination of any complaints lodged as a result of the new ban, in particular as regards the possibilities for the applicants to continue to enjoy the individual right to freedom of religion. So something is happening in regards to the situation of the ban of Jehovah's Witnesses and other problems being experienced by other groups in the Russian Federation. Something is happening, so we have confirmation we are in the right tracks. Then the last point I want to focus on is the granting of refugee status on the ground of religious persecution. There are refugees, people applying for refugee status that are escaping from countries that do not grant them freedom of belief, and in some cases harshly persecute and even torture them. What I'm very happy to recall is very important judgment issued not long time ago by the European Court of Justice, which is not the European Court of Human Rights. This is a different court of the European Union, not of the Council of Europe, and is based in Luxembourg. In September 2012, this Court of Justice, also called Court of Justice of the European Union, issued a very important judgment ruling in favor of religious freedom by identifying what type of infringements on freedom of religion do justify the granting of refugee status in accordance with the European Directive 2004 number 83 of April 2004 on the status of refugees. According to this directive, member states of the European Union should, in principle, grant refugee status to the applicant who actually face persecution on the ground of their race, religion, nationality, political opinion, or membership of a social group in the country of origin. In this specific case, the German authorities had refused to grant refugee status to 2 applicants coming from Pakistan, where their group was not considered as a Muslim group, while they claimed to be Muslims. They filed a complaint with the Federal Administrative Court that was not able to give a judgment on the case, so referred the case to the European Court of Justice in order to provide an official interpretation of the Refugee Status Directive. The court had to rule on what had been the common practice in Europe of only granting asylum on religious grounds in case of severe persecution of the applicants based on their faith, for instance, when the physical integrity of the applicant would be at risk only because of their belonging to a religious denomination. On the basis of such a narrow interpretation, a number of applications were being rejected. On the explanation, applicants could easily escape persecution by simply practicing their religion secretly at home in the country of origin. With this judgment, the European Court of Justice rejected such a narrow interpretation of religious freedom by adding that this goes beyond the private practice, and emphasized that, according to the same directive, some infringements of the right to manifest their religion in public also justify the granting of refugee status to the applicants, provided one, such infringements have a sufficiently serious degree of severity and that the public events that are likely to cause these attacks are prescribed by religion. Finally, the Court of Justice asserted that national authorities may not require an applicant to abandon public practice of religion so as to avoid a risk of persecution. So the practice of religion is a paramount thing. We must also say that this is an official interpretation of the directive that has authority on all member states of the European Union with respect to all applications on the ground of religious persecution, regardless of the concerned religion, regardless of the tenets of and beliefs of the specific group, and whether or not the applicant belongs to a religious group at all. They may be even atheists, unconcerned, people not belonging to any faith that are being persecuted for this reason, for not belonging to a religion. In fact, it is the same directive that is stating, and I'm going to conclude just 2 minutes, the directive says the concept of religion shall in particular include the holding of theistic, non-theistic, and atheistic beliefs, the participation in or the abstention from formal worship in private or in public, either alone or in community with others, other religious acts or expressions of view, or forms of personal or communal conduct based or mandated by any religious belief. There are, of course, so many other cases we could focus on. We don't have the time. I just want to conclude with a quote from Albert Einstein, a quote that I really like so much. It's from the book by Albert Einstein, Moral Decay, which was published in 1937. Albert Einstein said, "All religions, the arts, and sciences are in fact branches of the same tree. All these aspirations are directed toward ennobling man's life, lifting it from the sphere of mere physical existence and leading the individual towards freedom." This is what we are here for. We are here for promoting and implementing freedom. So I just wanted to share this quote with you. Thank you very much for your attention, and we will now have a break. Thank you so much. Thank you.